All right, everybody, welcome to the Creative Finance Collective. It's Tuesday afternoon. That means we get together and talk about all things creative financing. Today we have our friend Alan Seshker out of Texas and Sean St. Clair on here with us as well. How's everybody doing?
Doing good, doing good.
Good. If you are just now joining us, make sure to like and subscribe. And hey, you know what helps, especially just during a live show, is if you share it. So go on Facebook, YouTube, or wherever you're on, share the program so that other people can watch and ask questions. Because as you know, if you've watched before, we're on here for as long as we get questions about creative financing. I was going to mention a barcode, but the barcode's not here. I'm going to put it up. There's a barcode at the top of the screen, and go there. If you scan that barcode, that'll take you to the InRem Podcast YouTube channel, which is really the best way to engage with this kind of with our content, the best way to ask questions. Guys, I know we got a couple of things to get into. I found this interesting statistic. I don't really know that you'll have any comment for it. I just found it interesting, and it has to do with interest rates and housing affordability. But this was a stat put together by Fannie Mae. They were calculating, basically, they were measuring housing affordability and ways out of it, so on and so forth. But they say if U.S. income spikes 60%, U.S. incomes would have to spike 60%. If that happened, we'd return to pre-pandemic housing affordability levels. So if we suddenly saw a 60% spike in income, we would return to pre-COVID housing affordability levels. Or U.S. home prices, if they fell 38%, we'd return to pre-pandemic affordability levels. Or option three, if mortgage rates fell by 4.15 percentage points from 6.5%, that would take the interest rates down to 2.23%. We'd return to pre-pandemic affordability levels. Given those three options, I'm not sure there's a great chance that we're returning to pre-pandemic affordability levels.
I'll take the 60% increase in pay.
Oh yeah, that would be nice. I don't think anybody'd say no to that.
That's shocking numbers. So that's national.
Yeah, that's a national statistic by from Fannie Mae, and they're basically trying to base what would have to happen in those three areas to get us back to affordability levels that we were used to experiencing pre-pandemic. So you'd have to have major increase in price or incomes, major 38% drop in housing, or a major drop in mortgage rates. And I'm sure we're going to see, it's interesting that the average 30-year fixed mortgage is kind of spiked again. It's getting closer to 7%. And I think it was at 6.8 most recent. I'm sure it will fall as the tightening cycle eases, but is it going to fall to 2.23%? That's basically what Fannie Mae says would have to happen for us to return to affordability levels. That's hard to see that happening.
Well, I was in a room today with people who were a lot smarter than me, and they said that the powers that be say we've hit a little bit of a soft landing, and we're not going to see any more decrease for a while.
Decrease in what?
The interest rates.
Oh, you think what they're saying is soft landing, no recession. The interest rates have found their equilibrium. They've found their happy place, and this is probably where they're going to sit for the better part of get used to it.
Yeah. Any further poking would harm things in other directions.
Now, in the room of folks you were sitting with, is that do they think that the Fed itself is not going to continue to, like, their cutting is done? They did a half basis point cut and that's it, or they think they may do that, but it's not really going to impact mortgage rates much.
I think they were saying the second of the two.
Yeah, that might make sense. And you kind of see some of that. There was a drop to the low 6%. when they were anticipating a potential Fed rate cut. The Fed went further in their cut. They didn't do 25 basis points. They did 50. And it dropped a little bit, but yeah, it's trended back up since that time. Now we'll see what happens in the future, but that would be interesting. In other words, I mean, I think the bottom line is, the reason we bring this up is we're talking about creative finance, which is an investment opportunity to take advantage of historically low 30-year rate fixed mortgages that are sitting out there that you can buy and take subject to. Another interesting stat I saw, this was just from last week. These numbers are changing with interest rates because as some homeowners feel confident in selling, that where they had their low mortgages because interest rates dropped, more and more people are coming out of the different boxes of this survey. But currently, 25.4% of mortgage borrowers have a rate above 5%. So about a quarter, 25.4% of mortgage borrowers have a rate above 5%. 74.6% have a rate below 5%. So 3/4 of all the mortgages out there have rates below that 5% mark. Those numbers were a little bit different a couple months ago, because as obviously as homeowners have felt comfortable, as the rates got closer to the low sixes and selling, they did so and pulled themselves out of that three-quarters of the market that were below 5%. But and then as of that 74%, let's see if it breaks down. Well, I won't break it down further, but it breaks it down. There's huge of that 74%. There's big segments of that are either below 3%, 2%, and 4%. But right now we've got 25% of the folks above 5%. But it sure makes you think that creative finance is a strategy. It just makes you wonder at what point is it going to go beyond the investor space and more to the average consumer to try to take advantage of that strategy. In any event, interesting statistics that kind of paints a picture, I think, of when they say the affordability crisis of homes, what we're in and what kind of economic things would have to happen for us to see, pre-pandemic affordability levels. So
I think they all would hurt.
all of them would significantly. I mean, yeah, when you talk about a 60% increase in wages, that would feel good, I guess, for the moment, for the people that get that. But how many people would have to lose their job for employers to pay that? A 60% increase, that would be significant. 34% reduction in real estate prices to hit those affordability levels would be significant. A 2%, another drop to 2% mortgage rates.
I guess would that one hurt?
I wouldn't hurt in the short term. I mean, that probably causes inflation in the long term. It's a lot for them to do that. That's a lot of free money injected into the system.
Well, our 60% increase would do the same too, huh?
Yeah, probably. What's interesting is you might get a little bit of, if you dropped, it would depend on how fast it happened, but if you drop from a 6% down into the 2%, if that happened at all quickly, you would have a rush, I would think, to sell.
Refi.
Yeah, that, lots of refi, but definitely, that would put a lot more supply on the market, and that would simultaneously bring down probably home prices and affordability at the same time. I don't know, but that's what it would take, or at least what Fannie Mae thinks it would take. If you're just now joining us, this is the Creative Finance Collective. We're taking questions. So if you have questions, make sure to post them in the chat. We'll be on here as long as we're getting questions. Alan, when we were talking offline before Sean got on, you had mentioned you wanted to pose a couple of hypotheticals.
Yeah, I want to play a game.
Okay.
But before, can you call Fannie Mae and ask if we changed each one of those items, what it would need to change in order to get that affordability back to normal?
Yeah, I'll call my contact.
Okay, good deal.
Yeah, they're probably watching.
There you go. So they've already got the message.
They got it.
So I wanted to play a game. The reason I was in a room with people smarter than me is because of a national effort to to bring the consumer wraps out there. And I know, California and Colorado, I don't know about you guys, versus Texas, they allow the lease purchase options, they allow the contract for deeds. So I wanted to play a game of pros and cons of wrap versus contract for deed versus lease purchase option.
Okay.
So I'll start. On the, and I guess we got to break it down to pros and cons from the buyer side and pros and cons from the seller side. But from the buyer side, a wrap, you're the owner of the property. It's not the lease purchase option where we still need seller to complete it. It's not a contract for deed where we need seller to complete it. We can always draft around needing the seller to complete the contract for deed with some escrow agreements, holding deeds and things like that. But I think that's honky. So wrap is better for buyer side, getting the seller out of the transaction. All right, now y'all's turn.
So the way I always look at these is from the due on sell clause perspective, the tax perspective, the bankruptcy perspective, and future financing perspective. So those are the four kind of things that are different on all of these.
Due on sale. What was the other three?
Due on sale, you have in my view and experience, you have a greater risk of due on sale being called with a traditional warranty deed wrap financing structure.
Yep.
You have less, it can happen, but you have less of a concern if title remains in the seller using an agreement for sale or a land contract.
But you're still in violation of the due on sale.
You're still in violation.
It's not,
but have you ever seen it called? I've not seen it called.
No.
In that case.
Never on an LPO or a contract for deed.
Yeah. And then the next for due on sale is your lease with option. That's your lowest risk, because I've never seen that. And frankly, if you set up the option as a purchase contract instead of an option, then, is a lender actually going to, and Garn St. Germain allows you to lease up to 3 years. And it's vague as to whether or not you can put extensions, 3-year extensions, rights to extend, after that. And plus it's not even a recorded document. So due on sale for a lease with option to purchase is your lowest risk. Now, then you go into bankruptcy. Wrap with seller financing, to me, is your greatest bankruptcy protection if the seller files for bankruptcy, because you actually are on title. As long as they don't do it in 90 days, they generally can't unwind that transaction. Land contract, there is a bankruptcy risk because it is an executory contract, but the trustee would have to put you back into the status quo, which means give you your money back, any repairs you do to maintenance to the property, do that, give that back to you, as well as figuring out the fair rental value. And then if you pay more per month than the fair rental value, then you generally going to be entitled to that upside. So they have to put you back in the status quo, but if it makes sense financially to do that, then they can unwind that transaction, take the property back from you. And then the next would be for bankruptcy risk is your lease with option, because basically the trustee can just unwind that whole thing, give you your option fee back and call it good. And so that's your biggest bankruptcy risk. So it's kind of like this sliding scale of due on sale versus bankruptcy risk. Then you have tax benefits, right? So mortgage interest deduction and tax and depreciation, it depends on the CPA you talk to. But my understanding is the tax benefits, both of those tax benefits are available on a wrap as well as a land contract, that you can claim both of those benefits. You cannot, of course, as a buyer on or a tenant / optionee on a lease option, you don't get those tax benefits. Then the final thing is financing. Your ability, ease of financing. With a wrap with, warranty deed with seller financing, you could get third-party financing easier because you can actually secure it with a deed of trust against the property because you own it. Versus if you take it with a land contract, financing is more complicated. The only way that I know of that's somewhat simple, but you have to have a lender sign off on it. It would have to be a private money lender that understands all this stuff, or a hard money lender that understands this. But to secure a lender's position on a land contract after the transaction, so you want to do repairs, maintenance, whatever, the way you would do that for a land contract is you would assign the land contract to the lender so that they become then the purchaser, and then they would give you a secondary land contract with the terms of the financing.
So you would have to understand all this and be dumb.
Yeah. Right. But that's how you would do it if you were a lender. If you understood it, you would basically become the purchaser under the original land contract, and then you give the original purchaser a secondary land contract with the terms of the financing, so that once they complete it, you're wiped out or whatever, and then they reassume their position.
So that was from a buyer perspective.
That was from a buyer perspective.
What about a seller perspective? I guess
Yeah.
you want the least control over to the buyer. So lease purchase option is best for seller, then contract for deed, and I guess then wrap.
No, I think the best for the seller is the land contract. And the reason why the land contract is the best for the seller is because in most states, you're going to shorten the forfeiture or foreclosure time period. So in Arizona, I forget the percentages, Andy might know them, but as long as you're below, I think 40% of principal paid, you can forfeit in either 30 or 60 days, depending on where you fall. And it's if you have a servicer, you can do it out of court. And the other thing about that is you get the property back. There is no opportunity for a third party to show up and buy the property. That's what there is no auction. And the same, for example, here in Wisconsin, our redemption period is shortened to like 10 days, but you have to file a lawsuit and you do what's called a strict foreclosure action, and you can only do it on a land contract. And then you shorten the redemption period by like 7 days versus being 4 months under a normal foreclosure. But the strict foreclosure means I'm not going to pursue a deficiency and I just want the property back. But you get the property back. You don't have to go to auction and sell it. So if I'm a seller, I like the land contract. And then the next, I probably like the wrap because I don't want the wrap with seller financing, because I don't want to be responsible for the property anymore. I don't want, because no matter what you do on a residential lease, at least here in Arizona, I imagine it's same in Texas, like you can foist a lot of the maintenance obligations on the tenant, but you cannot force habitability items onto a tenant.
Yep.
And you're always going to be responsible for those. And so I don't, as a seller, I would never want that. The only time I would maybe want it is if I have an FHA loan, and maybe I'm a real estate licensee, I'm a title company rep, or somebody who I don't want to be blacklisted, with the FHA. And so, I'm going to do subject to that way so that I don't have those issues. Maybe I want a lease, but for the most part, I would rather do those other two options from a seller's perspective.
That makes sense. And then quiet on that. Fannie Mae and FHA are listening, so we don't want to talk about that blacklisting.
Maybe.
Yeah. They're watching.
They're watching.
All right. Good information. Good discussion. We do have a question. Before we get to the question, if you're just now joining us, this is the Creative Finance Collective. Post your questions in the chat. We're here as long as we're getting questions. And we're taking any creative finance related question, and we fudge on that. You know, if it's real estate related, we'll probably take it. In any event, so we've got a question from a YouTube viewer. Let me go ahead and read this to you. I have someone who entered into a residential real estate contract. Seller, and the contract states that no real estate commission will be paid to either party. The wholesaler is a licensed agent. They go on to say the settlement statement shows a commission fee being paid to the realty agency aside from the assignment fee, which is being named, quote, novation agreement. Can this be grounds for contract termination?
There's a lot going on. I think are y'all tracking the question pretty good?
Although I'm a little concerned, a little confused on, it sounds like the commission is being paid by the, out of an assignment fee, which I think would be a whole different ball of wax than the purchase contract.
I think it's being listed as a commission. It's not a commission, and it names it a novation agreement fee or a commission, but the title office probably isn't allowing the assignment fee, or in buyer lender maybe isn't allowing an assignment fee on the HUD, and so they're kind of monkeying with the terminology of it, utilizing commission. So as to the bottom line question, is it grounds for the contract termination? My answer to that's no. Might be able to argue voidable and get in there with a lawsuit, but it's not void.
Yeah, and I'm not even sure it would be voidable. I mean,
no.
You have multiple contracts. You have the purchase contract, you have the assignment contract. And as long as the seller from the seller's proceeds isn't paying a commission, or the buyer from the buyer's proceeds, or the buyer's not having to write a check, not the end buyer, but the original buyer is not having to write a check, and one of the assignors is writing a check from an assignment fee, I don't think it matters. I mean, that's a whole different ball of wax.
Yeah, I think it's trying to dance around the requirements of underwriters and lenders. It says seller's paying the commission from his proceeds. Well, that's
because it said it's being paid aside from the assignment fee, not from the assignment fee. Oh yeah, that's a problem. If the seller's having to pay it and it's reducing the seller's amount, and the purchase contract said no commissions are being paid, that's a problem.
Well, the title office isn't drafting up the settlement statement correctly. There's either commissions or there's not commissions.
Yeah, interesting.
I would give it the title office first.
Yeah.
And I had that actually occur one time. It was an assignment, and the title office didn't know how to do an assignment, so they had an ABBC. They had the AB HUD and the BC HUD, or settlement statement. And I said, do you have a second contract? They said, no, this is the way the underwriter told me to do it. I said, well, without two contracts, I don't think you can start drafting up two settlement statements. And all of a sudden, they just went away. Never heard from them.
That's funny. All right. If you're just now joining us, this is the Creative Finance Collective. We're taking creative finance questions, so make sure to post them in the chat. We'll be on as long as we're getting questions. We do have a follow-up question. Can you take a lien subject to?
So I think I understand that. I'm going to change the question to, can we move any lien over to Schedule B? Meaning, can we take a deed of trust lien and move it over to Schedule B and allow a mortgage wrap or a sub to? Can we take a HUD lien and move it over there? Can we take a mechanics lien, child support lien, abstract of judgment? And the answer to all those is yes. Oh, they did.
A TEFRA lien.
What's a TEFRA?
So that's like a long-term care lien where the state pays, so in Arizona we have them. So this must be an Arizona property. So those are liens where basically the government, the state of Arizona, their access or Medicaid pays for long-term care of somebody at the end of life. And then they record a lien because they want to get paid that amount back. And so they record a lien against any real estate that they own.
Like a MERP?
Yeah, it's probably the same, but different terminology. Yeah. We call it TEFRA in Arizona.
So
access lien.
We would be able to move a MERP lien over to Schedule B, but it's going to stay with the property and the investor is now going to have to pay it.
Right.
It's not going to be insured that it's going to be paid off at time of closing, but we can move that one over just like a mechanics lien.
Well, and that's just the thing, right? I mean, you can move property with liens shown as exceptions to coverage, which is, what people now call subject to. But you can move property, convey property with those liens out there, but you always run the risk that the creditor is going to come out of the woodwork and start a foreclosure proceeding against the property. And you're going to have to then deal with that lien, and you're going to be ultimately financially responsible unless you're willing to just let the creditor foreclose on the property and take it.
So that brings up a question, and let me ask your opinion. We've got these HUD liens, usually for distressed sellers not able to pay their mortgages, and so they go out there and get a $6,000 catch-up reinstatement mortgage, but somehow they're going to be written off and not collectible if you stay in the property for 3 years or what have you. They'll I'm losing my terms. Wipe it off, but that's not the word. Moving those over to Schedule B, taking exception to those, and allowing the property to be sold almost seems like it's more fraud than a wrap transaction.
Yeah, I don't like those partial claim liens or those catch-up liens. I like to see those paid off. And they're not big amounts. It's not, I did see one that was pretty big one time, but for the most part, like over 50 grand, but for the most part, they're, 5 here, 10 there, 20, they're not huge amounts. And I really like to see those paid off because at the end of the day, an insurance claim is being paid and they're actually coming out of pocket paying on the loan to get it caught up and then expecting that, they're going to get paid when the property's sold. So I like to see those paid.
I've seen a couple investors, quote unquote, roll the dice and say, we're going to move these over and take them, sub 2 and see if at the end of the 3 years they do waive those. They're obviously willing to pay them if they don't get taken off and waived, but I still think you're getting into a whole different area besides a mortgage wrap there.
I would not make that. Yeah.
And it might be the same with a TEFRA lien.
Yeah. Yeah.
So TEFRA is a statutory lien that is, they're statutory. Basically, they can record it. They can't foreclose unless the property gets conveyed. Then I believe they have the right of foreclosure. So the follow-up question was, what if the owner passes away, which at that point the loan is, or the lien is, due and payable. And you take it subject to, can you then negotiate the lien? Sure. I don't know why you couldn't. Obviously, if the property has sizable equity, they may not be willing to negotiate, but as we saw in the market downturn in 2008 and forward, I mean, everything's negotiable. So why not negotiate and see if you can, tell them, hey, you don't have to foreclose, you don't have to pay attorneys, you don't have to deal with any of this. So,
you think it's better to be? Do you think it's better to attempt negotiating that before or after the death of the owner? What do you think?
Well, I think it's after the death of the owner, but before the property is conveyed. So normally in the probate process, right?
Yeah, right.
Dustin Shanaker is a partner with our firm, and he does all of our probate work. Dustin negotiates these all the time as part of the probate process to try to get, a lower amount. But so you can, but I would like to see it done while you have the escrow open.
Only one I saw that's 100% non-negotiable that I've run into is child support lien here in Texas.
Mm-hmm.
The Attorney General's office is the one that's essentially owning that lien. However, the dollars don't belong to them, and they just simply state, by statute, we can't.
Right.
Yeah. Yeah. I think that's the same here. That's a tough nut to crack. If you're just now joining us, this is the Creative Finance Collective. We're taking questions. We've had a few good questions. If you got them, we'll be on here as long as we're receiving questions. So make sure to post them if you have them. We'll give it a couple more minutes to see if we get any more questions along that line. What else is going on in Texas, Alan?
So certain areas of the market getting hurt, certain areas not. We're getting a lot more requests for drafting deed in lieu of foreclosure. Investor giving up, got caught in between a hard money loan and the market. I've got 4 right now needing to draft up. I kind of don't like doing them. First, you got to do a title search, but even if the title search comes back clean, so many things can go wrong. Do y'all mess with deeds in lieu at all? Sure.
When the circumstance calls for it. I think as a general rule, we advise caution in the use of a deed in lieu of foreclosure. In other words, we think you need to do some due diligence if you're going to do it. Make sure you're not losing the benefit of what a foreclosure provides, which is wiping junior liens off title. But yeah. I will say that as the market's tightened up, I've started to see a couple foreclosures or possible foreclosures on wrap transactions where they're having to foreclose on the deed of trust because the original lender's not getting paid. You're seeing some of those where the margins might have been tight or whatever else. But yeah, we do see some deed in lieu of foreclosures when it makes sense to do that. Investors love it because they're cheaper and faster.
I embed in my deed in lieu that it's not a release of the lien, and that the lender, grantee, what have you, has the right to follow back up and conduct a foreclosure, even though they've taken the deed in lieu. Do y'all do the same thing?
No.
I didn't say it was enforceable.
I was going to say, I'm not even sure that's enforceable.
But I wrote it in there. I've never.
Don't you have a merger? Don't you already have a merger of title at that point?
I think we waived the merger doctrine or something like that.
Okay.
But it has not been tested. Now we have had to do it, and so there was no one contesting our foreclosure. So It just hasn't been tested by a borrower before.
Alan's got a big waiver clause. You waive all rights provided to you under the United States Constitution and Western civilization generally. You are now in the land of Alan Sashker.
It wasn't that bad. It wasn't. We waive the merger clause and we say the deed of trust and lien is not released, and there's no other releases, and we have the right to conduct the foreclosure.
Good stuff. Good stuff. Well, guys, that's all the questions we've got. Those were good questions, good discussion. Appreciate you being with us, Alan. And with that, we'll call it an evening, and we'll see you next time.
I appreciate the knowledge today, guys.
All right.
Appreciate it.